Lynn Ruffin Mitchell versus Jones et al.
Your appearances for the record, please.
Good morning, Your Honor. May I please the Honorable Court, Attorney Toy Thomas, P number 82295, appearing on behalf of plaintiffs.
Good morning.
Good morning, Your Honor. Katrina Tari appearing on behalf of Defendant Titan.
This is a motion to reopen discovery. Whenever you're ready, you may proceed. The issue here has to do with whether or not Samuel Wayne Mitchell was married, right?
Yes, that's correct, Your Honor.
Um, do you know anything about this, Miss Thomas? Because I know Mr. Latham had been meeting with the family. The case initially got dismissed because the family was fighting amongst themselves over who was going to be representing the estate. And I reinstated the case, and I know that Mr. Latham had been meeting with the family. So do you know if anything about this, if he has a wife?
That, Your Honor, I am not sure of that. And again, we're leaving it to the court's discretion on whether to reopen discovery, because we are not really sure of who Perry Mitchell is at
Mr.
this moment in
Charlie,
time.
oh, Miss Watari, your motion really kind of makes an assumption. People can be married, and that doesn't necessarily mean that they were living together or residents of the same household. This could have been his estranged wife that was living all the way somewhere else. So why do you think just because this person has been in probate court holding herself out as this decedent's wife, that necessitates that there was some other insurance coverage and your client should not be in the case?
Well, Your Honor, it wouldn't be under the resident relative portion of the statute. It would be under MCL 531.14.1, which states that it's the personal protection insurance policy to the person named in the policy, the person's spouse, and a resident of a relative of either domiciled in the same household. So if they were still legally married and she did have a valid insurance policy, her insurance policy for her auto would be higher in the order of priority than the Michigan assigned claims plan.
Do you have any reason to believe that she had a car or had insurance?
We do not, and that is why we are asking to reopen discovery so that we can attempt to determine whether or not she had insurance. So we will need to subpoena a deposition of Perry, what was her last name? Perry Mitchell, as she provided a certified copy of a marriage record. So we would need to subpoena her to determine whether or not she had a valid insurance policy at the time of the accident. If she did, we will then need to obtain a copy of the insurance policy. And then if she did have insurance, it would be that they would have to be brought in as they would be higher in the order of priority.
You could
Your
be
Honor,
going
that may
down
be
a
her.
whole, you
Oh,
could be going down a whole rabbit hole for nothing. This lady maybe didn't even have a car. But
It's
go ahead, Miss Thomas. What you want to say?
I just wanted to say that again, of course, if the court was going to reopen discovery, as you just mentioned, I think we would kind of be going down a rabbit hole, and it would just delay the process of what's going on, because again, she would be a non-party to this case. So she doesn't actually, even if they do subpoena her,
She
if
doesn't
she
have
fails
a
to appear, that's not going to be on us, and then that's going to delay this case even more. So again, I am leaving it, of course, to the court's discretion, but I did want to mention that for the record.
I guess I'm wondering, Miss Utari, you have other remedies too. If it turns out that there was another insurer that was higher in priority that should have paid, you could go after them at a later time, could you not?
We could, but that would cause further delay as well. And this part,
It
if
wouldn't cause further delay in this case.
not in this matter, but it would to us, as there would be higher insurance priority. Further, Mr. Mitchell would have lied during his deposition then, and this would be a material misrepresentation if he was actually married at the time of the accident. On his
But
application
he's
for
dead.
benefits,
Isn't he dead now?
he is, yes. But he did not disclose that he was married on his application for benefits. And during his deposition, he also testified that he was not married at the time of the accident.
Maybe.
So
I mean,
not only
but
could
how
there
do
be
we know
higher,
that he was?
we need to determine whether or not he was. We just have the information from Perry Stewart Mitchell that was filed in the probate case. And she did provide her address and the copy of the marriage certificate. So
Well,
we will need to determine
have
whether
you made any attempts to reach out to her and speak to her? Do you know if she's even going to be cooperative?
we have not yet. We just received these all. So she dated the letter March 21st. So we are just seeking the discovery be open for, even if it's a brief period of time, just for this limited purpose, to obtain the deposition of Perry Mitchell.
Here's the thing, though. She's not a party to this case.
Correct.
And you don't need my permission or discovery to be open to talk to this lady if you want to talk to her. Do you?
We don't just to talk to her on the phone, but we will to obtain her deposition.
Yeah, but you have insurance companies. I know they do. You have investigators. You have people that can go out and make contact with this lady, independent of whether or not I reopen discovery. I guess what I'm saying to you is that you haven't, I'm not sure that you've shown me enough that warrants reopening discovery in this case. When nobody's even made an attempt to even talk to this lady or see if she's even going to be cooperative, I could be reopening discovery for nothing.
Well, and that's why if we were able to reopen discovery and send a subpoena to her, she's more likely to comply with the courts with a subpoena from us than if
you think?
I would hope.
Think? I mean, we have cases I have cases all the time where, like, I'll give you an example. Just 2 weeks ago, there's a guy who has a lawsuit pending. He was injured and seeking benefits as a resident relative of his mother's policy, his own mother that he lived with, and she was not complying with subpoenas. She would not appear for deposition. And somehow we got a hold of a phone number for her, and I called her on the record and explained to her who I was and why I was calling, just to get her to even participate with the subpoena. I think sometimes subpoenas scare people more than a phone call or somebody just trying to talk to them. When they see subpoena, they think they're in trouble and they've done something wrong, and they get real dodgy when people start trying to serve them with subpoenas, in my experience.
Your Honor, if I may.
I thought you said you was leaving this to the court's discretion. Now you got a lot to say, Ms. Thomas. Go ahead.
No, I'm sorry. I just wanted to add to what you just mentioned, because I just had a hearing yesterday. It was a show cause for a non-party, as this, I believe, would potentially be. And it was our client's mother, and they don't have contact with their mother, and their mother failed to appear. So I just wanted to just kind of chime in on that portion of it as well. But again, of course, I am leaving it to the court's discretion.
Ms. Hutari, I think that you may have a valid reason to reopen discovery. And I'm not saying to you that I'm unwilling to do it, but I think you might need to do a little more legwork first, because we need to know this, because I think if you start issuing subpoenas, you might scare this lady off. Whereas if somebody just reaches out to her and tries to talk to her, you may be able to, get her to cooperate.
So if I may ask, Your Honor, if we could adjourn the motion 2 weeks, and then I will attempt to call her, and I have her email as well. So I will email her, I will call her, and if I need to, if she's unresponsive to me, I'll send an investigator as well.
Yeah, that's what I think you should do, because then that gives me a clear path to know, how long we need to reopen discovery and all that stuff.
All right, we will do that.
Okay, so we're going to adjourn your motion for 2 weeks to give you some time to do a little bit more legwork for me, okay?
Perfect, I can do that.
Okay, Kim, what's the new date for the motion, Madam Clerk?
June 13th.
June 13th, Ms. Hutari, okay?
Sounds great.
All right, I'll see y'all back on June 13th.
June 13th, Your Honor, is at 9 a.m.?
9 a.m. And if you supplement the pleadings, Ms. Hutari, you may not even have to come back. I may be able to just go ahead and grant the motion on the pleadings, okay?
Okay.
All right. Have a good
Thank
day.
you so much.
All right, thank you. Have a great weekend, everyone.
Have a great weekend.